There's been a trend of sort of repurposing these older laws to enforce data privacy when it comes to newer technology and to keep up with newer technology. Federally, you see lawsuits using the Video Privacy Protection Act, or VPPA, and on a state level, you see suits using various wiretap laws like the California Invasion of Privacy Act, or CIPA. Law firms, from what we're seeing, are arguing that tracking pixels violate these laws. When you access a website that uses a tracking pixel, these pixels send your information back to a server, or oftentimes third parties. A lot of times, for instance, we see cases involving Meta's tracking pixel. For VPPA cases, we see examples of companies providing streaming video content on their website and use a tracking pixel for that video. VPPA was originally meant to keep consumers' video rental history private, but now anyone who streams online videos can be considered a video service provider under VPPA. For CIPA and other wiretap lawsuits, you can be sued if you just use the tracking pixel on a resident of a state with a wiretap law. It's not what you might consider wiretap, but that's how these laws are being used, they're being interpreted, and you have to be careful. So there's a few things that you can do to combat these or work around these laws, right? Understand what technologies your site uses. If you use a tracking pixel, if you don't know what tracking pixels you're using, you can't reduce the associated risk. Be transparent with your users about what you collect and what tracking pixels you use, and make sure you're getting explicit consent for that type of tracking. It's also good to, anytime you can, minimize the tracking pixels that you use. If you don't need it, make that consideration from a business perspective.